The member for Mackellar.
Thank you, Mr Deputy Speaker. I'd like to thank the member for Fenner, who criticised the member for Hughes for not being able to make it through 15 minutes, but managed to fail to do that himself. Not that I would, not that I would encourage him to speak longer for the sake of speaking longer. Mr Deputy Speaker, when we look at this bill, I think it is important that we start from first basis. And the first basis of whistleblowing legislation is the removal of corruption in a systemic sense from institutions, whether they be government institutions, corporate institutions, or indeed charitable and political institutions. The reason that it is important for this parliament, indeed for our society, to make sure that corruption does not become a way of life in any of these institutions should be apparent to all of us. But it is the normalisation of aberrant behaviour which is what we seek to avoid and what every society must seek to avoid. Because once it takes hold, like a cancer, it becomes very, very difficult to separate and to remove from the corporate body or the corporal body of our society. As such, what we do here in this regards is very important. I am reminded of John F. Kennedy, who was the first modern president to ever hold televised press conferences. And of course he promised during his election campaign that he would make these media press conferences regular. He held about 5 a year. And of course this was considered to be something of a remarkable thing, that the President of the United States would make himself available 5 times a year to be questioned by reporters. Of course, in a Westminster system, this is something that would be seen as remarkable if it didn't happen weekly. But nonetheless, he was once asked, do you or would you prefer to live in the Soviet system, where Nikita Khrushchev, who was at that point the supreme leader of the Union of Soviet Socialist Republics and the Communist Party, would you prefer to live in that environment where you have complete and absolute control over what the media says and does? John F. Kennedy was taken aback initially by the question because obviously I don't think there is a politician anywhere in the world who wouldn't like to be able to tell the media what they should and shouldn't be allowed to say, and indeed get them to apologise when they don't say it properly. But Kennedy thought carefully about this and realised that in actual fact the inherent advantages in a free press, in freedom of speech, and indeed in allowing people to call out corruption no matter where it is taking place and no matter what their station in life is, was critical to a free society. And he said, I think, something that was quite remarkable when you think about it from the viewpoint of the 1960s, which is the advantage of a free system is not its efficiency, but is indeed its dynamism, is its ability to adapt and meet people's needs. Now, of course, Marx, when he was writing Das Kapital, said that the benefit of capitalism is its ability to adapt, its ability to change. So the problems that I foresee today will not be the problems that capitalism has tomorrow, and how true that has proven to be. But in Kennedy's answer is, I think, the key to why whistleblower legislation is so important. Because it is not that we must have a just and fair society. It is not that we must have a free society that respects order, that preserves what is best about our society. We must be seen to have those things as well. For a free society to advance, for a free society to thrive, every participant in it must believe critically that that society gives them the opportunity that they may not have in any other system to participate in the opportunities and benefits that that society provides and that is capable of being provided by that society. It is not good enough, in other words, for people to believe that the system is rigged against them. And I sometimes think when I stand in this place, Mr Deputy Speaker, that it is most unfortunate that we have over and over and over again the perception of political leaders telling those younger Australians that they have no hope and that they have no future because the system is horribly rigged against them. This legislation, more than anything else, will ensure that that perception, that claim never becomes a reality. Because above and beyond all else, it ensures that people who take the critical step of blowing the whistle on what they see as aberrant behaviour are doing something that none of us can ever do from Canberra. They are behaving as individuals in their place and at their time, with knowledge that cannot be contained by a single person, to point to the aberrant behaviour that otherwise may go unnoticed, unreported and certainly uncorrected. And that is why whistleblowing legislation is so important. I noticed the Minister at the table is the former chair of the Parliamentary Joint Committee on Corporations, one of the best committees to be a member of, Mr Deputy Speaker, in this parliament, and not just because Senator John Williams is a member, but because it does great work. Senator John Williams has been known to eat lunch and indeed have it brought for him. But the important thing about what the Corporations Committee did early in 2017, one of the first inquiries when I came to this place, was to have an inquiry into whistleblower legislation. And I think that it was an interesting inquiry because I had not really considered it in depth until that point in time, and the benefits and costs of not having whistleblower legislation. And certainly the benefits I've highlighted, and there is much more to be highlighted in this piece of legislation in front of us and protecting people. But there was a particular professor, Professor AJ Brown, from a Queensland university, who is considered and was very knowledgeable and, more importantly, very wise on this issue. He posed some important questions to us, I thought. And one of them was whether we should have an omnibus or a single point of protection for people who wish to make a whistleblower claim. In discussing that, I think I actually ended up disagreeing with him. And I think this legislation points to that. Why? Because I think in a legislative approach, having competing legislation actually ensures that we can test different provisions and we can determine whether those provisions are being used or abused. So, for example, in the United States, Abraham Lincoln, one of my favourite political leaders and certainly one of the wisest that I've read about, introduced a piece of whistleblower legislation that talked about where if you called out a piece of corruption, you as the whistleblower were entitled to a percentage of the damage that that was doing. The result of this, of course, in the United States, being the United States, has been that people, and in particular law firms, have become industrialised this and created economies of scale. So what you have is private companies being constantly bombarded with claims of corruption by whistleblowers, because what they're really after is a 10 or 20% payoff from the quantum of the alleged corruption. This has, of course, made the whistleblower legislation in the United States very contentious because people claim that whistleblowers are not coming to the table with clean hands, that whistleblowers are not, despite claims to the obverse, are not coming to the table with pure motives, and indeed that some are motivated by financial payoff. And of course, some law firms have used such provisions to ensure that people get paid out rather than taking it to court. It's important that this legislation, and Australian legislation, does not go down that avenue, because what it would do is not create an avenue where corruption and aberrant behaviour was being called out increasingly, but may in fact create an industrial scale assault on institutions, both government, political and charitable, where you will find that there are people who are not doing what is right. One of the other points that Professor Brown made, which has stayed with me and I see is encapsulated in this legislation, is that when you see whistleblowers standing up for, in another institution, high-profile whistleblowers standing up on merit against corruption, against aberrant behaviour. It sends a shock through the cultural institutions across a society. And one would have to think, and there have been many fine speeches in this chamber, about some of the corruption and some of the aberrant behaviour in our charitable organisations and indeed some of our churches. There's been a royal commission into that, Mr Deputy Speaker. And many of those crimes, because they were crimes, took place in a time and place in Australia where it was not seen as appropriate or not seen as the done thing to dob on your mate or to call out corruption. And we as a parliament must always make it clear that calling out corruption, no matter at what level, and calling out aberrant behaviour, no matter at what level, is part of our Australian culture to do so. Because when you do it, it protects the institutions on which so many Australians rely and trust. I'm told that when you look at modern opinion polls, trust in institutions in our contemporary society is much lower than it was at other times in our society. I've always found this a matter of irony, because I think that our institutions now are more transparent than they used to be and are certainly less capable of being corrupted than they used to be. And when I say irony, as the Speaker would prefer, I think of a sense of ironical, because what we have is a situation in which these sorts of bills, this sort of legislation, ensures that wherever you are, you can undertake and be clear that where there is aberrant behaviour, you can report it and you will be protected in making that report. But what is also important that we don't do, which I know those opposite, or some of those opposite are advocating, is we must never reward a person for doing that. Because the minute you do that, you introduce a new motive into the system, which of course creates doubt as to what was motivating that person to do what they want. In the Commonwealth, we've had numerous cases at ComInsure where people have made claims and had those claims upheld. One famously for a person who went to a conference overnight, was booked into a hotel room, and during an act of great excitement, managed to bang her head on a lamp. ComInsure said, at the Administrative Appeals Tribunal, they found that ComInsure was liable for that person's damages or that person's hurt and injury, because they were essentially there for work. Now, of course, I think most people would say that doesn't pass the pub test. I would say why you want a bunch of drunk people testing you is a matter of quizzical. I don't quite understand why we have the pub test in Australia. I thought you'd want sober people to be judging what you're doing, but apparently not. But some people would claim it doesn't meet the pub test to have people going on a work function and then behaving irresponsibly and somehow making their employer responsible for their behaviour. In New South Wales, we have very similar whistleblower legislation to this at the state government level. And what we have found is that that legislation has been misused. Effectively, where it's been misused is by employees, who, when a manager calls them in and informs them that they will be performance managed because they are not undertaking their task and role as required by their employment contract, they normally, or not normally, but there have been many, many instances in which people claim instead whistleblower protection, and therefore the performance management must go on hold while this is investigated for 12 to 24 months. It is important that whatever legislation we put in place and the purpose for which it is put there, it undertakes and achieves that purpose and is not misused by those who would seek to use it for other reasons.
Thank the member for Mackellar.